Good morning, everyone. It is, believe it or not, this is our 17th year of the notorious Gov Hutchison. So welcome, Gov, and take it away.
Well, that was a nice brief introduction. Thanks.
I told you.
So I like it. Morning, everybody. I wish I was there with you in the Modesto State Theater like it usually is, but maybe next year. We can hope. But today we will do what we normally do there. We'll do it virtually. And that is me giving you a legal update of what's going on, laws and forms and stuff like that. Let's start with the obvious topics, just the latest on COVID. There really isn't much. We keep getting asked these questions like, oh, it's getting bad. Are we going to have these PED forms back and all that? And the answer is no, I don't think so. Remember, basically with COVID, you're back to the way you were before COVID, other than the mask wearing rules, right? And these are different in a lot of places. Like where I am in Los Angeles, everybody's supposed to wear a mask. If you leave your house and go inside somewhere else, you're supposed to be wearing a mask. But that's LA County, and that's Sacramento County, and San Mateo, and San Francisco, and Santa Clara, and Contra Costa, Alameda, and Yolo, I think. Excuse me. I don't think there's anywhere else that has that rule that you have to wear your mask regardless of your vaccination status. If you're not in one of the areas I just mentioned, you're really only supposed to wear a mask if you're unvaccinated. But in the places I mentioned, so we're talking about real estate, we're talking about showings and open houses and stuff, right? So in the places I mentioned, which is the Bay Area, LA, Yolo, Sacramento, you are supposed to wear a mask regardless of your vaccination status at things like tours and open houses and showings. Otherwise, you're really only supposed to wear it if you are unvaccinated. If you're vaccinated, you don't have to. Well, how do you tell the difference? Well, it can be on the honor system, right? I mean, there's no rule that you have to check someone's status or ask them. But keep in the back of your mind, of course, a seller, it's their house. They can have whatever rule they want. I mean, a seller can say, I just want everybody wearing a mask. I mean, it doesn't matter if that's not required where you are. It's a seller's house, right? They can have whatever rule they want, and they can require people to prove it. They can ask the question. They can have the honor system. It's really up to the seller. And, everything I just said is also true for a business, a store. Some places like LA, where I am, everybody's got to wear a mask. Other places, no, it's really the same general rule of you should be wearing a mask when you go into someone's office or company if you're unvaccinated. Now, but an office, a company, your company, any company can have its own rules also, right? Can be stricter than that if you want. So that's basically where we are with COVID. It's the mask issue, and that's the only issue you really have to deal with now, other than all the other rules you had to deal with for the last year and a half, right? Could things change? Things just keep changing, as you know. You just got to be flexible and keep up with stuff. But that's the latest on the rules for that. One more thing about offices is kind of an interesting rule. If you have an office like your office, like I said, the basic rule is, unvaccinated people should be wearing a mask. But there's a distinction in an office between independent contractors like you and employees, in that if it's a W-2 employee, the office is supposed to just keep track of who's vaccinated and who isn't. They're not treated any differently, but you're just supposed to keep track of it. And by the way, there is an exception in an office where you don't have to wear a mask. Number one, if you're in a room all by yourself, and number two, if you're eating or drinking, just like a restaurant, right? So anyway, latest on that. Next topic, related topic, evictions, eviction moratorium. You heard probably that the federal moratorium was extended. We don't really care because we got a California moratorium that goes beyond that. California moratorium, of course, end of September. Now, the federal moratorium goes to October 3rd. So there's going to be like 3 days there where there's only going to be a federal moratorium as opposed to a state moratorium, it doesn't really matter so much. What the basic rules, which you've had to deal with for months now, is two basic things. Number one, if someone's not paying their rent and they have a COVID reason they're not paying their rent, you cannot evict them. They're still supposed to pay 25%. So first question is, how do I know whether they have a COVID reason or not to be paying the rent? And by the way, I'm just talking residential. The only way to know is you send them a notice to pay rent or quit, not the 3-day pay rent or quit. From now until the end of September, it's still the COVID pay rent or quit, the PRQTP. It's actually the PRQTP2. It's the pay rent or quit transition period 2. It's on the zip form. You can't miss it. So you give them that form. They got 15 days to respond. If they respond in 15 days with a declaration of COVID financial distress, which is attached to that pay rent or quit form, landlord cannot evict them. Can I evict them on October 1st? Yeah, if they don't pay their rent for October. But can I evict them for the back rent they haven't been paying? As long as they've been paying 25%, you can't evict them. What if they've been paying the 25%, but they haven't been paying the 75%? What can I do on October 1st? Well, obviously, like I said, if they don't pay the full rent for October, you can evict them. But if they've been paying the 25% and starting in October, they start paying 100%, what about that extra 75%? They just owe you the money, but you can't evict them for not paying it. But please be aware that everywhere in California, landlords are eligible for rental assistance. There is money here for you to get. In other words, all you got to do is be a residential landlord. The tenant owes you money based on COVID, and you can get rental assistance. There is one catch, and that is you only get it if your tenant's income is less than 80% of the county median income for a household of their size in a rental situation. How do I do this? You just go to this website called housingiskey.com and then look up your city, look up your county. You'll be able to file an application. You have to give them your tenant's email address. They'll send the tenant an application. Tenant fills it out too. Assuming your tenant's income is less than 80% of the county median income, you get the money. You get 100% of what the tenant owes you. It's been a slow process, but it's there. So you really have to apply for it. And guess what? Come October, let's say you try to evict a tenant for not paying you money. You're going to have to prove you applied for rental assistance. So it's like, you might as well do it. It's going to hurt your ability to evict the tenant in the future if you don't do it. So it's a smart idea to apply for this money because you're entitled to it. You paid your federal taxes. This is federal money that came back to California. So do that. One more thing related to rentals about this extension is, if you didn't know already, there was this new disclosure form that came out called June 1st, called the Ntra 3, Notice of Tenant Relief Act 3. If you are a landlord and you have a residential tenant who owes you money, give them this form now, the Ntra 3. If you don't, you may have a delay evicting them come October. And of course, I keep assuming that this eviction moratorium is not going to be extended again. That's what they're saying now. We never know. You'll know, we'll all know when it comes to the end of September. But that's where we're at right now. Now, the other big part of this law is, so in other words, what if a tenant owes me money, but it's not related to COVID? You can evict them right now. What if they're not letting me show? Evict them. What if they have pets they shouldn't have? Evict them. What if they're causing a nuisance, causing damage, engaging in criminal activity? What if they have subtenants they shouldn't have? You can evict them right now. Well, what if they're not doing anything wrong? I just want to evict them because I want a new tenant. Normally, if it's a single family house or a duplex or a building newer than 15 years, you could just do it. You don't need a reason. But part of this eviction moratorium is you need just cause to evict a tenant if the tenant's not doing anything wrong. So the key question, of course, is you want to sell the house. Can I kick a tenant out because, I mean, they're paying the rent and everything, but I want, or even if they're not paying, can I evict a tenant because they're selling the house? And the answer is yes, but it's not quite that simple. You can't evict the tenant until you get a buyer in contract. Can I just say to the tenant, we're going to sell the house, you got to leave? Nope. You got to put the house on the market, get a buyer, have the buyer sign an offer, seller accepts it, then you can give the tenant a 60-day notice. All right, let me get to your questions because they're related to this. But by the way, Ben, the question you just asked, the form that I was talking about, the disclosure form that every tenant must receive if they owe money, it's the Ntra 3. And I'll put it in the chat. Okay? That's the disclosure form that every residential landlord must give the tenant if they owe you money, if they're behind in their rent, even if you don't know why they're behind in the rent. If they're behind in their rent, give them the form to protect your ability to evict them in the future. Okay? Anyway, so let's get back to this. Seller wants to sell, renter doesn't allow someone to view the house. Well, that's grounds to evict. They have, unless you're in LA County, or maybe other couple counties in the Bay Area, I'm not sure, they have to allow you to show the house. If they don't, that's grounds for immediate eviction. Okay? But what if they let you show it, but they don't want to leave? Like I said, once you get a buyer, you can give them a 60-day notice. Not the normal 60-day notice. You got to give them the COVID 60-day notice, NTT, notice to terminate tenancy. But you can evict them. But there are two other ways to evict a tenant, by the way. The owner can say, I'm evicting you because I want to move in. But you can't say, okay, I'm evicting you because I want to move in, then move in for a week and then sell the house. You got to actually, most courts will say, if you're going to move in and use that as your excuse, you got to stay there for like at least a year. And there's a third possibility. Landlord, you can just take the house off the rental market. And that's grounds to evict the tenant. Well, can I take it off the rental market and then sell it? Yes, you can. But when you take a house off the rental market under California law, in other words, if that's your excuse to evict the tenant that you normally otherwise wouldn't be able to evict, you have to keep it off the market for at least 2 years. Maybe that's okay. Maybe you can sell it to a buyer and the buyer is willing to the buyer doesn't want to rent it out. The buyer's not going to rent it out, in which case that's another way to get a tenant out so you can sell the house. Or you can just get a buyer in escrow and then it doesn't matter. The buyer doesn't have to commit to not renting it out if you're following all this. Okay? By the way, about that rent assistance to the landlord, the landlord initiates it. You go to that website, but then the tenant has to participate in the process. What if the tenant doesn't participate in the process? Well, then you have a problem. You would think they would want to participate because if you get rental assistance, the tenant doesn't owe you the money anymore. You would think a tenant would not want to owe you the money, but whatever. What if the landlord doesn't want to do it? Well, then the tenant can actually initiate it on their own. But basically, it's supposed to start with the landlord. Okay? Okay. So I think we're good on rentals. If you have questions, keep asking them. Let's talk about not COVID stuff. Okay? Let's talk about other stuff. Someone says, I have an owner harassing tenants. I mean, I'm not sure exactly what that means. Harassment is obviously illegal. By the way, there is no rent freeze or anything. Landlords can increase rent. There are restrictions depending on what type of property it is, of course. if it comes under the California rent control law, which is typically buildings over 15 years old, you're limited to 5% plus inflation, and that's measured by whatever county you're in. You can call CAR to get the number. There's a statewide 10% cap on rental increases right now, regardless of the type of property. But if you're not under California rent control or some local rent control, you can increase the rent up to 10% right now. So anyway, but you can't increase it by more than 10% in a year. So I'm not sure what, Grace, what your person is doing. Anyway, let's talk about some other stuff. What else is going on? Are there any other big new laws or big new forms this year? And there's one big one. The biggest new law and the biggest new form. And by the way, real quick, Roddy, yes, this applies to all residential rentals, not just single family. It applies to, multi-unit properties as well. Okay. All right. So what's the biggest new law that just happened this year? You all know what it is. It's the defensible space and fire hardening. Remember what happened 6 months ago on January 1st? There was this new home hardening form you had to give to all buyers if they're buying in a high or very high fire hazard zone. Then on July 1st, there's a new disclosure law regarding defensible space. And then they combined those two laws into one form. So here's what you got to know. I mean, basically, if you think about it, the last 15 years or so, there have been 5 big disclosure forms you always have to deal with. The NHD report, the TDS, transfer disclosure, the seller property questionnaire, the lead paint form if it's pre-78, and these disclosure booklets, right? The earthquake booklet, environmental hazards booklet. 5. I always said there are 5 things. Well, now there's 6. This is a brand new mandatory disclosure form. There are now 6 mandatory disclosures in California. The 6th one being the fire hardening defensible space advisory. What's different about this form is it's only required if the house you're listing is in a high or very high fire zone. Remember, everyone in California, there's four possibilities. Number 1, you're not in a fire zone. Number 2, you're in a moderate fire zone. Number 3, you're in a high fire zone. Number 4, you're in a very high. This form is only required in the last 2. If you're not in a fire zone or you're just in a moderate fire zone, the form is not required. You can provide it as information if you want to, but you don't have to do it. So the first question for a listing agent is, how do I figure out what type of fire zone I'm in? And that's pretty easy. That's why we have an NHD report. But the NHD report, if you've ever looked at it, when it comes to the fire zones, they have 2 fire zones. One is very high fire zone, and one is wildland fire area. What if neither box is checked on your NHD report? You're not in a fire zone, this new form is not required. What if the very high fire zone box is checked? Well, obviously, you're in a very high zone, this form is required. What if the very high box is not checked, but the wildland fire box is checked? What is that telling you? That's telling you you're either in a moderate or a high zone. But Gov, you just got through telling me I only got to do this other form if it's in a high. So how do I tell in this situation whether I'm in a high or a moderate? You just push your NHD provider. They know they're going to get this question. They will have the answer for you. They can tell you. Some NHD companies I've noticed have even modified their reports to put it right on the report. Bottom line, though, if you're in a wildland fire area, you push your NHD company, make them tell you if it's a high or moderate. Let's say you're in a high. Okay, this form is required. So you pull out the form. Now, the form has 5 paragraphs. The first 3 deal with fire hardening. The first 3 are the same paragraphs that were in the form that was out for the first 6 months of this year, the DDHA, the fire hardening form. So bottom line is, seller, you're just giving this information to the buyer. Now, as a listing agent, the second thing you have to ask yourself is, was this house built before or after January 1st, 2010? If it was built before 2010, the seller has to check those boxes in paragraph 3 of the form, indicating, does the house have a wood roof? Does it have dual pane windows, etc.? If the house is built after January 1st, 2010, even though you're in a high or very high zone, the form is required, but the seller doesn't have to check those boxes. And you know what? They wouldn't check any of the boxes anyway, because everything built after January 1st, 2010 was built under the new fire code, which if it was built in a high or very high zone means it couldn't have a wood roof. It had to have dual pane windows, etc. So listing agent, the first thing you figured out is, am I in a high or a very high? The answer is yes. So you pull out if the answer is yes, you pull out the form. Second thing you ask yourself, was the house built before or after January 1st, 2010? If it was before, you have your seller answer those 6 questions in paragraph 3. Now we go to paragraph 4, the defensible space part. This is where it gets slightly complicated because there are 4 boxes in paragraph 4B. There's 4B, 1, 2, 3, and 4. And your job as a listing agent to figure out which box to check. Actually, you either check box 2, 3, or 4. If you don't check any of their boxes, it defaults to box 1. What do I got to do to figure this out? It's very simple. You have to figure out, when you take a listing, wherever you have your listing, is there a local defensible space law ordinance where I have it listed? So the big picture is California has this law, right? That if you're in a high or very high fire zone, you're supposed to have 100 feet of defensible space. That's the old law. It's nothing new. This new law doesn't change that. You have to do that. And if you want to know what that means, what does that mean, defensible space? Well, right on the form, paragraph 4A refers you to Public Resources Code 4291. You look that up, tells you what it means. You know, you have to be something like between 30 feet of the house. The tree branches have to be a certain distance from each other. Beyond that, the grass can't be more than 4 inches high. It's stuff like that. It's right there. Okay. That's California law. But some local counties and cities have got their own laws. So you have to ask yourself as a listing agent, is there a local law here? But it's not enough, is there a local law? The real question is there a local law that requires the buyer or the seller to do something at point of sale? I'll give you an example. I know, for example, Sonoma has a law, Napa has a law, Marin, a lot of counties have these laws. Mendocino has a law where they have this local defensible space rule. It says you got to comply with the local rule and the state rule. But none of those laws require the buyer or the seller to do anything at close of escrow. There's only a couple places we've found so far, mainly in the Lake Tahoe area and I think a couple in Marin County, where they actually require the seller to go get an inspection before close of escrow or something like that, or the buyer has to do something. So if you're in one of those areas, you may have to do something and you're going to check the box on this form, either 4B3 or 4, saying there's a local ordinance that requires you to comply with this before close of escrow or requires the buyer to get documentation after escrow. By the way, how do I know in my area if there is a local law? The easiest thing to do is call your local fire company or call your local CAL FIRE office and say, is there any local law here that I got to do something before close of escrow? And the answer is they're probably going to say no. You can look it up. Like I said, there aren't many places that do this. So normally, I think what's going to happen is you're going to determine that there is no local ordinance requiring the seller to get an inspection before close of escrow or requiring the buyer to do something. Most of your transactions are going to be either 4B1 or 2 on this form. Well, how do I know what 4B2 says? If the seller has already obtained documentation of compliance with the state defensible space law, they're going to give that documentation to the buyer. So the last question you have to form, the old form was the DDHA. The new form that I'm talking about right now, I'll put in the chat, is the FHDS. That's replaced the DDHA. So this is the form I've been talking about. So let's get back to the listing agent. You got this checklist of 4 things you have to do. Number 1, determine if the property's in a high or very high fire zone. You do that by looking at your NHG report or asking and then asking your NHG company if it's not clear. Second thing on your checklist, determine, was the house built before or after January 1st, 2010? If yes, make your seller check the relevant boxes in paragraph 3. If not, you skip that. The third thing you have to determine is there a local defensible space or vegetation management ordinance that requires the seller or the buyer to do something at point of sale? The way to find out about this is call your local CAL FIRE office or I would call my local fire company, because CAL FIRE has been we've learned that CAL FIRE has been giving some confusing advice. We've noticed that CAL FIRE thinks, oh yeah, everyone has to every seller has to do a defensible space inspection before they sell a house. That is false. You can quote me, that is completely false. Sellers only have to do a defensible space inspection prior to close if there's a local ordinance that requires this. And there aren't many of those. CAL FIRE seems to think that this state law that I'm talking about requires sellers to do this, and the answer is they don't. But anyway, so let's say you've determined, number 1, you're in the high, very high. Number 2, you figured out how old the house is. Number 3, you figured out there's no local ordinance requiring the seller or the buyer to do anything. The fourth and last thing you have to do is ask your seller a simple question. Hey, seller, in the last 6 months, has some fire agency been out to your house to check and see if you have 150 defensible space? Has CAL FIRE or a local company come out? And if they say, yeah, as a matter of fact, they were here a couple months ago. Really? Did you pass? Yeah, I passed. Do you have that piece of paper? Sure, here it is. We'll give it to the buyer. You'll check the box in 4B2 and give it to the buyer. I suspect more often than not, the seller's going to say, nope, I haven't had an inspection in the last 6 months. Which means your transaction is probably going to default to paragraph 4B1, which says, if you haven't noticed it yet, it says the buyer is agreeing that within 1 year after close, the buyer is going to obtain documentation of compliance with defensible space laws. So what this means is, listing agent, you're done, you've done your job. Escrow closes. Now the buyer has a year to go out and try to get documentation of compliance. In other words, to get an inspection. Listing agent, is it your job to explain to the buyer what they have to do? No. Buyer's agent, is it your job to explain to your buyer what they have to do? Yeah, your fiduciary duty probably says yes. So when it comes to this form, buyer's agent, you only have one job. When the buyer gets the form, you look at paragraph 4, see if any of the boxes are checked. Chances are none of them are going to be checked, which means it's going to be 4B1. So you're probably going to explain to your buyer, you see what you just agreed to here? You just agreed that within a year after close, you're going to go out and get documentation of compliance with defensible space. The buyer's naturally going to ask you, how do I do that? The answer is very simple. If you're in a state fire responsibility area, you're going to call CAL FIRE. If you're not in a state fire responsibility area, you're going to call your local fire company. Well, how do I know if I'm in a state responsibility area or a local? You can always just call CAL FIRE and say, hey, do you have jurisdiction over my property? If so, I want you to come out and inspect for defensible space. In CAL FIRE, they've hired a whole bunch of new inspectors. They're ready for this call. But CAL FIRE will also tell you, you know what, you're not in a CAL FIRE area. Then buyer's going to call the local fire company. Say, hey, I just bought a house. That means I'm supposed to call you to ask you to come out and inspect the house and get me documentation of compliance. We've learned that some local fire companies will do this. We've also learned that some local fire companies are going to say, nah, we don't have the resources to do that. We don't just come out and do inspections just because you ask us to. We just do random inspections or we respond to complaints. So no, we're not going to do it. Hey, if that's what they tell you, buyer, you just write down the name of the buyer. I just talked to John Smith at the local fire company. He said they're not coming out. They don't do this. You're done. End of story. You don't have to do anything else. What if the buyer says to you, you know, let's do this before close of escrow. Let's call the fire company or CAL FIRE before close of escrow and have them come out before we even close. Problem with that is the purchase contract says the buyer is not allowed to do a government inspection without the seller's permission. I think you're good. And maybe this isn't going to come up much for you at all, but it's just something to be aware of. What else is going on? Are there any other new forms or new laws you should really know about? There's only one other new form that came out recently, and that's the transfer of listing form, TOL. I mean, this may never happen to you. You don't have to transfer listings. But let's say you have an agent come into your office from another office, and they're bringing a listing with them. And their current broker is okay with this. We now have a nice form to document very carefully the transfer. Takes care of agency, takes care of liability, takes care of compensation, takes care of files. So it's a good form, but it's not mandatory. Any other new forms that came out recently? Well, a couple months ago, as you've noticed, there's that fair housing addendum, which is attached to your contract. Not necessarily required, but it is already pre-attached. So you're encouraging your clients to read it so that they can't come back to you later and say, my agent never told me about, I can't discriminate against this group or whatever like this. Yeah, you did it. I gave you the form. Another form that came out recently is that California privacy law addendum. That one is mandatory. So make sure you don't detach that one, okay? And then I'm glad you asked the question about the love letters. So on this, what are we talking about here? When buyers make offers, sometimes they don't just make an offer, they also write a personal letter to the seller. Is there anything wrong with that? It's not that there's anything wrong with that as a concept, but it does perhaps create some risk for the seller. Because remember, in California, when you get an offer or multiple offers and you're deciding which one to take, I mean, you don't have to take necessarily the highest offer, whatever, but your decision about which offer to take shouldn't be based on the personal characteristics of the buyer. In other words, you're choosing between two offers. It shouldn't be based on one has kids and one, I like families with kids. I'm going to take their offer. It shouldn't be based on obviously their race, their religion, their skin color, where they were born, there's what they do for a living, whether they have a disability, their immigration status, their citizenship status, their medical condition, whether they're a veteran or not. And this form I just mentioned lists all 22 categories. I guess the problem with these letters are sometimes the buyer will write a letter. Yeah, my husband and I and our 3 kids, one of whom is disabled, will love this house. It's a beautiful house, just works for us. We just moved here from, Italy or something, and my husband's a dentist and blah, blah. They tell all this information. Now the seller knows where they're from, what they do for a living, how many kids they have, whether they're married, whether they have a disabled person. What's wrong with that? Well, then let's say the seller doesn't take that offer, or they take a different offer. Someone can come back and say, well, how come you didn't take my offer? Must be you don't like kids, or you don't like people from Italy. You know what I'm saying? I mean, it's sort of like, as a seller, if you don't know this information, you can't be accused of bias. Now, I know with Google, a lot of sellers are going to look up the buyers anyway. You can tell a lot from their name, sometimes their background. You may meet them. Who knows? It's just the thought is, just think about the issue of the more information as a seller, personal information I get from the buyer, I'm more vulnerable to an accusation in the future of bias. Plus, we all have unconscious bias anyway. We don't even know we have. Sometimes you're just inclined to accept offers from people who are like you, which may be not right, because you may be, in other words, you're basing it on someone's personal characteristics. Okay. All right. So, by the way, I'm glad you asked that, because you probably noticed on the listing agreement now, there's a checkbox. There's a situation where the seller has to make a decision to either say to their agent, give me these letters, or I don't want these letters. It's like, not the letters are illegal, but the seller now has a way to, the seller has to make a decision. Do I actually want these letters? Maybe I don't even want these letters, based on the reasoning I just gave you. Okay. By the way, you also notice on the listing form now, there's a place where the seller can tell the listing agent, yeah, I authorize you to order all this stuff now at the time of the listing. Remember in the old days, or maybe still now, you wait till you get a buyer before you order like the prelim and the CC&Rs and stuff like that. It's become a more common practice for the listing agent to order this stuff as soon as you take the listing, so you're ready when you have a buyer. Anyway, there's a place on the listing form to do that. Other things that are going out there that affect your listing that haven't been resolved yet, that are in the process of, hopefully maybe one day we're going to have a definition, a statewide definition of what days on market means, or what does coming soon actually mean. Things like that. I mean, there's all sorts of things in play that haven't been resolved yet, right? So all you can do is, usually sometimes there's a local rule as to what that means. And all you can do is convey what the local rule is. Changes to the listing form, the new fire hardening form, the not mandatory but attached fair housing form, the mandatory attached California Privacy Act form, and that's really it for new forms. I got a question real quick. What if a buyer waives all their contingencies at the time of the offer prior to reviewing disclosures? Do they still have a 5-day review period to cancel? That's an excellent question. And the answer is, contingencies and disclosures are two different things. So even if you've removed all your contingencies, even if you write an offer with no contingencies, once you get these disclosures that I mentioned, the TDS, the lead paint, this new form, right, the defensible space and fire hardening, those trigger a 5-day right of rescission. The buyer can get out of the deal. But did you know there's a way to get around that? If the listing agent gets the buyer to sign these disclosures prior to signing the offer, then they do not get the 5-day right of rescission. What if you attach the disclosures to a counteroffer? They still got 5 days. But if you actually say to the buyer, we will not look at your offer unless, in other words, you make the disclosures available, they get the disclosures, and you actually say, I want your signature on these disclosures dated prior to when you sign the offer. If that's the case, the buyer does not get the 5-day right of rescission. But that's the only way to get rid of the 5-day right of rescission. The contingencies are different. And by the way, we're getting a lot of people writing, I'm sure you're hearing about a lot of non-contingent offers. And sometimes the buyer doesn't really understand what that means. That means you don't get the loan, too bad. You don't like the inspections, too bad. You've committed to buy it, subject to that 5-day right of rescission that you might get following delivery of the disclosures. You know what else we're seeing? We're seeing buyers write things like, my offer is $10,000 more than the appraised value. But they don't really understand what that means. The seller doesn't really understand what that means either. You have to really draft that pretty carefully. Like, my offer is 10 more than the appraised value if the property doesn't appraise at the purchase price, blah, blah, blah. Or they'll write things like, my offer is $10,000 more than the next best offer. What I'm really saying is, when your buyers try to get creative like that, these clauses have to be drafted in a very specific way. So you might want to call the legal hotline if you have a buyer wanting to do that. So make sure it's worded properly. Ideally, I'd say have your buyer get their own lawyer to help them draft it. But since that's probably not going to happen, you might want to call the legal hotline to make sure that it's drafted properly. Okay. Now, speaking of forms, a couple more things, if you give me a couple more minutes. The other big thing that happened, of course, is Prop 19. It's in effect. I think you all know about it. But remember, the basic rule is, if someone is over 55 or severely disabled or the victim of a wildfire, they can sell their current house and take their property tax they're paying on their current house anywhere in California. And they can do this 3 times, even if they've already done it once under the old law. Remember, the old law said if you're over 55, you could take your property tax with you, but you had to buy a new house in the same county, or you could go to a couple other Bay Area counties. And you could only do it once, and the new house had to be cheaper than the old house. Now, if you're over 55, disabled, or a victim of a wildfire, you can take your low property tax on your current house and move anywhere in California, even if the new house costs more than the old house. I'll give you an example how this might work. Let's say your seller bought their old house a long, long time ago, 30 years ago. Bought it for $100,000. Now it's worth $700,000. So they're paying property tax based on $100,000, but it's worth $700,000. They're over 55. They want to sell. So it's now worth. They sell it for $700,000, and they buy a new one for $800,000. Under the old law, their property tax on the new house would have been $800,000 because it costs more than the old house. Under this new law, their original house, they have a property tax base of $100,000. It's now worth $700,000. They sell it for $700,000 and buy a new one for $800,000. What's their property tax basis going to be on this $800,000 house? It's going to be the original $100,000 on the original house plus $100,000, plus the difference between the purchase price of the new and the sale price of the old. So it's going to be $200,000. Which is a lot better than a property tax basis of $800,000. So if you have any of your clients who are like hesitating to sell because they're worried about they're going to get slammed with big property tax hike, that might not be the case. In my scenario, if they sold their $700,000 house and they bought a new one for less than $700,000, their property tax isn't going to go up at all, which is a good thing, right? Filene, I'm looking at your Q&A there. does the love have to be presented with the offer, the love letter, you mean? No, I mean, the point is some buyers want to submit a letter to the seller. And obviously you have to tell the seller that you got a letter. The question is, the seller now can make a decision, well, maybe I don't want that letter for the reasons I explained. So in other words, if you're a buyer's agent, your buyer wants to submit a letter, you submit the letter. Listing agent, if you get the letter, you got to tell the seller you got a letter. But the seller, based on what they've read on the fair housing form, or what they've read on the purchase contract, may decide they don't want the letter. Let me get to a couple questions here. Randy Brown, does the size of the new home related to the old home matter? Nope. It's just a question of the price. What if one of the buyers is over 55 and is buying a multi-unit property with family members to be able to care for them? So they're buying more than one distinct legal property. They can only do this if they're going to live in the property. And obviously they can only do it for the portion that they're going to live in. So in other words, this Prop 19 only applies to your primary residence. And by the way, you can buy the new home before you sell the old home, as long as the two transactions happen within 2 years of each other. That's a very, James, my friend, has a very good point here. These ever-changing rental laws. And he's asking a logical question. I'm telling you all this stuff, but should you really be using this information? And the answer is no. I'm glad for bringing that up. In other words, I think a lot of you may be landlords yourself. So I want you to know what the rules are. And of course, call the legal hotline. But let's say you have a client who has a tenant. In other words, you're not a property manager. You just happen to have a client who has a tenant. And they're starting to ask you about these complicated rules and can I evict? Can I not evict? What form should I use? You should not get involved with that. This stuff is way too complicated. You should tell them, listen, you need to get a qualified California real estate attorney to help you. I want you to know this stuff. We have Q&As on this stuff. Some of you may be landlord yourself, as I said, but you are not the person to be giving the advice to the tenant. Oh, here's the right form to do to give them this 60-day notice because you're taking it off the rental market. You want to call the hotline, we'll help you with that. But you shouldn't be the one providing that information. What if there's only two buyers and only one has a property that qualifies to transfer the tax base? Well, then, depending on how they're going to take title, maybe you're going to only transfer the property. The rate on the new property is going to be a blended rate, right? It's going to be blended. In other words, it's because one of the property owners is over 55 and one isn't. By the way, you can buy the replacement property before you turn 55. You can't sell till you're after 55. Sell the other part, right? But I mean, you could do one half of it before you turn 55. Okay. And by the way, this doesn't happen automatically. If you're over 55 and you want to transfer your property tax base, you have to actually go to the assessor's office and ask for the form to do it. They're not going to do it for you, but it's a good thing you should do. Tina, I think, asked a related question on property taxes. They got to be within 2 years. In other words, you can buy first or sell first, but the two transactions have to close within 2 years of each other to be able to transfer the property tax. Speaking of forms, I'm sure there's one thing you all want to know about, and that is the future change in forms. So this year's been a light year for forms, other than all these COVID forms, right? I mean, you know, all these COVID eviction forms and all those forms you don't need anymore, like the PED forms and the posted rules of entry. Thank goodness they're all gone, right? And you still got to deal with these eviction forms. And there's this defensible space form and the transfer of listing form. How about between now and the end of the year? Are there going to be other major form changes? Well, there's actually only going to be one, but it's a doozy. It's the purchase contract. In fact, all of the purchase contracts, we have like 7 of them, right? We got vacant land, new construction, residential property, condo conversion. You know what I'm saying? We got a bunch of them, and they're all changing. By the way, we don't have a probate or a mobile home form anymore. We just have an addendum for that. Anyway, the point is, the purchase contract, the form you use every day, the most important form by far that you ever deal with, is changing. End of December. How many pages is it now? 10. How many pages is it going to be end of December? 16. What are you doing to us, you're thinking? And by the way, how is it going to go from 10 pages to 16 pages? Are there going to be a lot of new paragraphs in there? No. It's just all the paragraphs you're familiar with. A lot of them are going to be longer. They're going to have more explanations. Because I think what we figured out since the last time the form changes, certain issues keep coming up time and time again. Certain problems keep coming up time and time again. Certain things people are confused about over and over. So the forms committee basically decided, we're not going to worry about how long this form is. We're going to make it so that we anticipate every issue that comes up. Everything from the distinction between regular refrigerators and wine refrigerators. Those cause arguments. I mean, there's so many things that come up time and time again that cause problems in transactions that can be fixed if you just put into the contract, you address that issue. So that's really why it's going to go from 10 pages to 16 pages. So obviously, it takes a while. It would take like 2 hours for me to go over every change. There is one fundamental change in addition to what I just said, and that is there's going to be a new paragraph that puts all in one place, all the places where the buyer has to fill in a blank. Right now throughout the contract, certain paragraphs the buyer has to put in like, who's going to pay for this? Or what's the deadline for the loan contingency? Or what's the deadline for the walkthrough? Or who's responsible for paying for this or something? I mean, there's blanks to fill in paragraph 3, paragraph 1, paragraph 7, paragraph 14, paragraph 8. There's all sorts of places throughout the contract where the buyer has to fill in a blank and make a decision. Well, all of those parts are going to be in one place, paragraph 3. So that's the only place where a buyer is going to have to fill in blanks. And I think the good thing about that is it's going to be hard to skip anything. Because once in a while you hear about buyers, they skip something because they didn't catch it, right? You didn't catch it either because they're all spread out through the contract. Well, it's going to be all right together, and all 8 contingencies are actually going to be in the same place, which I think is great. Right now, the contingencies, the loan and the appraisal are in paragraph 3. Selling your home is in paragraph 4. Reviewing a solar lease is in 8. The disclosures are in 10. The inspection contingencies in 12. The prelim contingency in 13. They're all spread through the contract. Now there's going to be right in this paragraph 3, all 8 are going to be right there. Now we're still going to have all these other paragraphs. There's still paragraph, the same paragraphs you're familiar with are still going to explain the details of how it works. How does a notice to buyer to perform work? How does the solar lease reviewing that work? How does a prelim work? Selling the home, loans, and all that stuff. It's still going to be in there. But as far as filling in the blank as to how long is the loan contingency, or who's paying for the escrow report, or how long do I have to do this, those blanks are all going to be in the same place. You know what I'm really saying to you, though? But there's so many changes in this form, and they're good, but you need to know them. I'm recommending that sometime between now and December, you take a class. We're going to be offering a whole lot of classes, virtual classes, online. I'm going to be doing a lot of them. I'm starting next week. It's probably going to be worth your time of 4 hours to sit through one of these classes. And the company can organize one too, by the way, to sit through one of these classes. Some of you know, every time I go to the Modesto State Theater, I usually teach a class there, and some of you go to it. So the class is really good because, first of all, I think the class is good anyway. Plus, it's going to explain all the new stuff. Plus, you know what you get with the class? You get a 100-page book for you to keep that you can refer to anything you want, that it actually line by line explains everything. So I'll be teaching the class, pointing out all the changes, and also just teaching in general as if you never even knew what the old form said. And there's going to be a nice 100-page booklet that comes with that. Yes, it's not free. It's $75. Some places have a discount. I think it's worth it. Just for the book, it's probably worth it. Plus, starting in October, we're going to have a weekly free webinar that you can always look at. I think each webinar is going to talk about 2 pages of the form or something like that. So anyway, obviously I can't give you much more detail than that. That's sort of an overview, but there are a lot of changes, and most of them, I think all of them are good. I'm not on the forms committee. I don't make these changes, but I like them because I always say, oh yeah, that always comes up. Yeah, I'm glad that you addressed that there. Oh yeah, that makes that clear. People always don't understand it. Now they understand. Now they're going to be able to understand it. So get ready for that. That's going to be the only form change. The way everybody can sign up for a class, I'll put that in the chat also. You go to the website, store.car.org. That's the website. Look up RPA training, and they'll give you all sorts of options. I think some local associations are doing one. So if you're a member of one of those associations, you could sign up with them. But there's also going to be a whole bunch of ones that are just open to everybody. So you can go there, look it up, and pick the one you want. We'll probably be scheduling a lot of them. We've already scheduled a bunch, like 30 or something, but we'll probably do more. And like I said, the webinars will be coming too. We'll give you information on that, probably starting mid-October. Is anything else coming? Of course, this COVID stuff, we have no idea. I thought by now I'd be out traveling. I'm not. CAR is having a meeting in Anaheim in first week of October. Is it going to be a live meeting? At this point, yes. Things keep changing. You don't know. You guys have to be just flexible like you've been for the last year and a half. We all thought it'd be over by now, but you know, a lot of the worst is over as far as all your rules. Just stay flexible. If things change, stay flexible. If any of you guys have your own rental properties, thank you, James, for pointing out that you guys should not be giving advice to your clients with tenants on evictions, when they can evict, how to do it, because it's complicated. And you may not get, even if you explain it right, they might not understand it right. And then they accuse you of giving them bad advice, even though you gave them good advice, but they just didn't understand it. So it's not an area where you're required to give them advice. There's certain areas as a realtor, you're legally required to be able to explain disclosures to them. You're legally required to be able to explain, purchase contracts and things like that. Unless you're getting paid to be a property manager, you are definitely not legally required to be able to explain rental laws to your clients. And you shouldn't, in this current environment with this complicated stuff, you probably shouldn't. Just like you shouldn't be giving them tax advice either. It's okay to give them this Prop 19 advice. And everything I'm talking about, we have Q&As on our website that you can just give to your clients. always call the legal hotline. We'll send you whatever. We can send you good stuff to give to your clients. Efren, what about liquidated damages and arbitration? I'm not sure what you mean. What about them? They're still going to be in the new contract. As you know, those are the only two paragraphs that require to be initialed. I'm not sure what else you're really asking about those two paragraphs. James, thanks. You guys have a referral person. You refer when your clients have landlord-tenant issues. That's a good thing to have. Very good. How retroactive is Prop 19? Remember the effective date was April the 1st? I got good news for you. If you bought you could have bought the replacement property before April 1st. And then you sell the new property after April 1st. In other words, you can do one of the transactions prior to April 1st, but you can't actually transfer the property taxes until after April 1st. So it is a little bit retroactive. If you did both legs of the deal before April 1st, it's not retroactive. Remember, before April 1st, the way it worked is you could only do it once. You had to stay in the same county. And if the new property cost more than the old property, you couldn't do it. The change of Prop 19 is you can do it 3 times. You can move anywhere you want. And you can even do it if the new property costs more than the old property. As far as retroactivity, if you did one leg prior to April 1st, you're still good. And as far as the age requirement, you could have done the first part before you turn 55, as long as you do the transfer after 55. Okay? We got a great Q&A on this. You can give to your clients if they have questions, so you can call the hotline. And I think, ladies and gentlemen, that's about all I have for you today. It's been a crazy year, as you know. Hope you guys are doing well.
Great. Thanks, Gav.
My pleasure.
This is, like I said, year 17. Hopefully by year 20, you'll be in person back at the state theater.
I sure hope so.
We do too. I sure appreciate your time.
Okay, guys. I will see you later.
Great day.